Good afternoon, everybody. Thank you for joining THBD's August Lunch and Learn webinar. Today, we're excited to welcome Timothy Snowden, owner of Bold Ventures Patents, as our featured speaker live from Temple. Timothy has a wide range of experience working in a variety of small and startup business environments in both patents and product development. Today, he'll provide a comprehensive snapshot of the importance of protecting your ideas. Timothy, thank you so much for joining us today. And before I hand it over, I'd like to review some quick housekeeping tips. Please submit your questions in the control panel underneath the questions tab. We will address these at the end of today's presentation. You can also find a copy of today's presentation in your go-to webinar control panel under handouts. We'll upload a live recording of today's presentation to THBD's YouTube channel after the event. With that being said, take it away, Timothy.
Good afternoon. Thank you, Mary. Thank you, everybody who's here with us digitally and in person. And it's a pleasure to be able to spend the next few minutes talking about bootstrapping intellectual property, or how we take and protect your invention as much as possible while protecting your capital and cash flow as much as possible. Like Mary said, my name's Timothy Snowden, and I'm with Bold Ventures Patents. I'm a registered patent agent who's had a few years of experience working with a wide variety of patents. So I'm looking forward to sharing a little bit of what we've learned with you. We're going to start out by covering why you would want a patent, what a patent is, and when you should start thinking about a patent. We're going to touch on a few of the concepts of what actually makes an idea or invention patentable, and then move into some of the best practices that you should be thinking about regarding patents in your startup business. And then we're going to look at some bootstrapping techniques, bootstrapping being pulling yourself up by the bootstraps, getting as much as you can out of everything you've got. And so we're going to try and give you some techniques to help you do that with a startup company. First, what is a patent? Why should you patent, and when should you patent? Fundamentally, a patent is protection. The idea of a patent is to protect your invention for a period of 14 to 20 years, depending on the type of patent that you're eligible for. It's granted by the government. That means it's court enforceable. What it does is it gives you a right to exclude. Just because you have a patent on something does not mean you have a right to use it if somebody else has overlapping patents or something like that. But it does give you a right to exclude others from using your particular invention. The point of this is to give you a few years to commercialize the patent. It provides barriers to keep other competitors away for about 14 to 20 years, which hopefully gives you time to bring it to market and get your feet under you and recoup some of the investment that you've made in inventing it, commercializing it, reducing it to practice. Because of this, investors in startup companies and small companies and purchasers of larger companies often look very carefully at the number of patents you have, the quality of patents you have, if you have patents at all, because if you don't have patents, then their investment may go to the wind when another competitor comes in and copies it and takes away all their investment in the high-dollar research. Flowing from this idea is actually that patents actually improve the public good. And this is because ideas require added value. Only about 25% of a product or a service is the actual idea behind it. It's about 75% of the value in that product is the value added during commercialization, taking the idea and making it a reality, research, development, marketing, telling people it's there, telling people why they need it, telling people how to use it, bringing a distribution channel on board, in order so that you can actually get that idea to people in the form of something that they can use. Because of this, you need that patent or patents to hold people away while you're commercializing and enable you to get some of that commercialization cost back without people copying it. Therefore, because ideas must be developed to be useful, the development investment needs a return. This is a classic example. A classic example of this is the National Institutes of Health. Originally, because it was public funded research, the government did not allow patents to be taken out on any of the inventions, any of the research products from the NIH funded research. What this did is it made the research unavailable to the public because nobody would take the idea and invest the money in commercializing it because there was no protection to keep, as soon as they brought it to market, somebody making a direct knockoff, short-circuiting around all their development costs and offering something at a much lower cost. Therefore, they couldn't be sure that they could almost be assured that they would lose all that investment. Once the Bayh-Dole Act was passed by Congress that allowed patents to be taken out and licensed on publicly funded research, the research quickly became commercialized and started becoming available to the public in the form of actual products and services. So we see that patents actually enhance public access to research, both private and publicly funded. So that's great. You need a patent because it helps you protect your patent and bring it about and actually do some good with your ideas. But what is a patent? At its heart, a patent is an exchange between the inventor and the public, and it's mediated by the U.S. Patent Office. Patent is an old English word going back even further to various roots. It means to make open. Bioscience people may be familiar with the congenital heart defect, patent ductus arteriosus. It's an opening that shouldn't be there. Well, a patent is actually an opening that should be there. You make your invention available to the public so that they're aware of it, so that they can build on it, so that it enhances access to research and ideas. And in exchange, the public, through the government, gives you a temporary exclusivity in order to recoup the investment you made in that research. So when should you patent? As soon as possible. Patents are time critical because the United States and most of the world is on a first to file system. The first inventor to the patent office wins. If there's two inventors who invented it and one actually invented it a few days later, but they got to the patent office first, they would be the ones with the patent. Furthermore, there are a number of time bars, typically approximately 1 year from the date of disclosure or commercialization or attempt to commercialize, that bar you forever from getting a patent if you have not filed at least a provisional application before the deadline is reached. You should be aware, however, that some countries actually have what's called an absolute novelty bar, which means that if it is disclosed at all, you don't get a patent. So you actually need to file with some nations immediately before any disclosure. So we know when to patent, we know why to patent, we know what is a patent, but what is patentable? Fundamentally, there's two main questions you ask with an idea. Is it useful? Is it new? When we're looking at it, if it is useful, we're going to look, does it solve a problem? Or is it already known to the public as an abstract idea or a law of nature? Second, is it new? Is it novel? Absolutely new. Is it not obvious? New, but pretty much already known. And has it never been disclosed to the public before? In other words, are you not taking something back that already has been given to the public? So first, does it solve a problem? Because it's an exchange where you're receiving value from the public by a period of exclusivity, you actually have to give something useful to the public in the first place. So the patent statute actually provides for any useful process, machine, manufacture, which is a product, or composition of matter, which typically you think of as being a chemical or some sort of mixture, something like that. Furthermore, is it specific? Is the innovation actually useful and substantial right now? You cannot patent an idea. The idea has to have been reduced to practice, so it's actually useful right now, and it has to actually work. In other words, does it operate? Those four statutory categories are the only things allowed to be patented. They're very broad, but they primarily are used to exclude abstract ideas. You cannot patent, for example, a mathematical equation because that is simply a way of describing a fundamental idea of nature, the way that the creation works. And therefore, you would be actually taking something away from the public. It was already known long before any of us were born. If you tried to patent a mathematical law, a natural law, the law of gravity, a genetic code, something like that. However, if you take those and actually make something useful with them, implement it in a specific way to solve a specific problem, that then becomes patentable. When you look at whether this useful idea is new, you want to know, obviously, has it ever been come up with before? Is it a new process, a new machine, a new product, a new chemical, or an improvement on one of those things? You don't actually have to come up with a new car, but if you make an improvement to the car, you can patent the improvement. This is called anticipation. If you talk to patent agents and patent professionals, is what all that means is, was it anticipated? Was it already known at the time that you filed the application? A natural extension of that is the idea of, is it obvious? This is another way of asking, is it new? So not only a nice example here is if I have a blue car and I know how to paint cars yellow, I can't patent a yellow car, because even though nobody's actually patented a yellow car, they patented a blue car and they know how to make it yellow. Everybody knows how to make it yellow. It's a predictable idea. Somebody who wanted a yellow car would easily know what to do. And what this does is it actually preserves everyday creativity and adaptation. If you didn't have the concept of non-obviousness, engineers, scientists wouldn't have jobs anymore, because it would all have to be patented. And you would have a plethora of patents that you wouldn't be able to work around. It would actually be taking away what's already known, just not specifically said. Third, when it's new, is we look at, has it already been made public? If it's been made available to the public without a patent, you can't take it away. The United States actually provides a 1-year grace period. So if there's been a public disclosure, you actually have 1 year from the date of that disclosure to file a patent application. However, what a lot of people don't realize is that immediately upon disclosure, including some offers for sale, you start what's the 1-year grace period. If you go 1 day after that grace period and file a patent, the patent is null and void, the application is null and void, and you're not able to get a patent. As we mentioned earlier, some countries require absolute novelty. As soon as it's disclosed to the public, it's no longer patentable. As we were just looking at, any sale starts the 1-year time period, even if it's a secret sale. A sale, according to the courts in the FAF decision, is it a commercial sale, or an offer for sale? Even if you didn't close the sale, but you offered it or somehow gained commercial benefit, even if it was under a non-disclosure agreement, once the invention was ready for patenting, which means it was ready to use, then you start the 1-year time clock ticking. So this can include discussion, even if there's no formal offer to sell the product, if you were trying to get it commercialized after it was ready to patent. The idea here is to motivate people to go ahead and start the patent process and get the invention disclosed to the public as soon as possible. So now that we've looked at what is patentable, let's go into some of the best practices for building a patent portfolio and protecting your invention. These can be summed up in 3 points: file early, and file often. There's most of the patent applications that you're going to be working with are one of 3 types. A provisional application allows you to get a 1-year placeholding. It will not actually turn into a patent unless an actual full utility application is subsequently filed within 1 year. But what it does is it puts your disclosure on file with the patent office and allows you to say, here's my filing date. Now I don't have to worry about public disclosures, offers for sale. It gives me a little bit of time to commercialize it without having to go through the whole process of claims primarily. The catch with the provisional is that you only get to use that filing date if the application actually disclosed everything that your later application is going to cover. So while you don't have to go through, a patent application has 3 parts: a description, drawings, and claims. Okay, a description and drawing makes someone know, as we're looking down there, it makes a person of ordinary skill in that art be able to make your invention without a lot of experimentation. The term is undue experimentation. So, and then the claims are the other primary part, and they describe what of your invention that you've described you actually consider to be yours. You don't have to write the claims in the provisional. but you do want to make the description as robust as possible. If you do that, then you can file a non-provisional within a year and gain access to that earlier filing date and have been working on commercialization in the meantime without having spent as much time and investment in the original application while you were proving things out. The non-provisional is just what we were talking about. This only applies to utility applications, which means that it's a useful invention. It has utility. The other primary type of patent application that you will run into is a design application. This covers ornamental features that have no inherent use in and of themselves. They're very useful in allowing you to cover the look and feel of your product and keep people away from doing direct copying. You'll see them used a lot in packaging, in automotive industry. In fact, we were just talking about the other day, we realized Ford changes their vehicle designs about every 14 years, which is the life of a design patent, precisely because all of their body panels, shapes, and everything have design patents on them. It keeps people from directly copying the way that their vehicle looks. And you can use that very similarly. The second concept, besides just to file an application, is to file early. The American Invents Act switched the United States from a first to invent system to a first to file system in 2012, like we mentioned earlier. The best practice, therefore, is as soon as you come up with an idea and you reduce it to something that's actually usable, to file that with the patent office as a provisional or design application before you make any disclosure to anybody. This makes you as safe as possible. If you're not able to do that, or you accidentally disclose it before you're aware of that, the second best plan is to record every time that you've disclosed it to somebody and track the dates to make sure that you file an application before 1 year. The one thing you want to avoid is to wait 364 days after your first disclosure and try and file an application. Not only will you not be able to find someone who can file it in 1 day, you'll end up trying to file an emergency provisional application, which risks the disclosure not covering everything that it should have, and then making you end up with either a poor patent or a deadline that you missed because what you really needed to include in there didn't get included. The third concept is to file often. One of the great uses of provisionals is that you can file with every improvement. We all know that we don't come up with the product the way that we're going to sell it at the time of invention. So you can file a provisional, you make an improvement, file another provisional covering that improvement, file another provisional, and then within 1 year from the date of the first provisional, you can actually wrap multiple provisionals together into a single application that describes it exactly as it is at that point. But you've had all those improvements on file with the patent office as early as possible. The second concept that goes along with this is to keep records. Include all your potential variations, things that you tested and you didn't like quite the way they worked, uneconomical variations that you don't really see how they're going to make money at this time, because you can still include those. And at the very least, what it does is if you include those in your patent, it keeps competitors farther away from your core idea by not allowing them to creep up close with other variations. The other thing that keeping records does is it allows you, if you're in that 1 year grace period and somebody gets to the patent office before you, but you can show that they actually stole the idea from you because they saw it, you disclosed it, they saw it, and then they filed a patent application on it. You can actually get the patent application assigned back to you if they derive that idea from you. The other thing you do by filing often is build a patent portfolio. A single patent by itself is critical, but it's not near as strong as it should be, especially if you're building a startup that you're looking for somebody to invest in, for somebody to buy at a later date. Investors know that there are strength in numbers. Not only does it provide you a larger fence to keep competitors further away while you establish yourself in the market, it also makes it harder for competitors who are trying to invalidate your patents in court. It makes their job harder because they've got a lot more patents, a lot more claims to invalidate than if they had a single one. Now that we've covered some of the best practices, let's wrap up our discussion of patents with some techniques that you can use when you're evaluating patent applications, when you're evaluating patent professionals, when you're trying to build your portfolio, to bootstrap your intellectual property just like you're bootstrapping your startup, to maximize your cash flow while still getting a valuable patent portfolio built up. We're just going to start by taking a quick look at what the application process looks like on a broad scale. Your patent professional works with you and files an application. And depending on whether you're looking at a design application or a utility application, you may hear back within 6 months if you're really, really, really doing well with the design application. Typically, you're looking more at 18 months to 3 years. Sometimes it goes further than that. You almost assuredly will get a rejection the first time. That's the way the patent office works. Their job is to try and make sure that there is absolutely nothing that they can find that's close to your invention. So they'll find something and claim it is. Your patent professional works with you to draft a response. You're typically going to both argue that the patent office misunderstood your invention, misunderstood the prior art, and you'll probably want to amend your claims to clarify and how your invention is distinguished from what they're citing against you. This will typically go on at least once, if not 2, 3, or more times, depending on how broadly you're trying to claim, how crowded that particular industry is with known art already, and go from there. Every application is allowed 2 responses. After 2 responses, you can either file a continuation application or a continuation in part where you can add more information and still claim priority of the original application's filing date for the original information, etc. If everything goes well, you'll get an allowance that you can then pay an issuing fee and be issued a patent. So with that in mind, that's sort of what you're going to want to expect when you're looking at the application process. And one of the ways that you can add a lot of value to the patent application process without having and still maximize your capital investment is to recognize that cost and hours are approximately the same thing when you're talking about a patent professional. Their cost is directly related to how many hours they have to spend on it. So if you can do the expensive legwork yourself by providing them not only the description of your invention, but provide to them variations that you've thought of, variations that you hadn't thought of, detailed descriptions, sketches, compare it to all the existing solutions that you know of. How have people been solving this problem already? Badly or not? What is the closest thing? How can you apply this to other industries? And what other industries might the patent office be looking to cite against you? By doing this, you allow the patent agent's time to be spent on the areas where they can add the most value, where they can put it in the format that the patent office expects, where they can describe particular variations, avoid particular words, describe it in legal words that the patent office is going to expect. For instance, did you know that there is a legal difference between comprise and consist? If I told you that fruit salad comprised grapes and strawberries, I would be right. It also has pineapples in it, but comprise means that it includes what I said, but it might include more. If I said that fruit salad consisted of strawberries and grapes, I would be wrong, because consisted in patent legal jargon means that that's all that's in it. So there's a lot of things you can do without accidentally that the patent agent is there to help you make sure that you get the broadest, strongest patent application drafted that you can. By allowing them to spend their time on those types of things instead of having to research and understand your invention and describe it, which frankly, you're the inventor, you understand it better and can describe the art better than they can anyway, then you can minimize how much time they have to spend on that and maximize how much you maximize the value that you get out of what you spent. The other thing is that when you're looking for a patent professional, you're going to want to ask them if they negotiate with the patent office. There's a couple of different philosophies on dealing with rejections, but one of the most fruitful is to make prosecution as fast as possible by engaging in dialogue with the examiner. Call him up, have interviews with him, sometimes even before the first rejection is issued. And it allows you to avoid long-term misunderstandings. I don't know how many times I've talked to an examiner and I said, we're really having trouble understanding your rejection here. You're saying this, and this is what we're describing. And they go, oh, that's not what I was saying at all. Or you explain to them what the invention does, and they go, oh, I didn't understand that. And you say, okay, well, now can you suggest some language that might help, and you negotiate things out? It doesn't always work exactly like that, but a lot of times you can move forward a lot more quickly by just spending about 30 minutes on the phone with an examiner. And so you're going to want to look for a patent agent or professional that does that. The other thing you're going to want to do is part of the negotiation is you're going to expect to propose amendments. You're going to claim as broadly as possible when you first file your application, as broadly as you think you can get, expecting to have to narrow that down as examiners find things and apply things that you weren't really expecting. And so if you narrow down the claims as quickly as possible, it allows you to get and you negotiate with that examiner on what they'll allow. Then you can get a patent issued and get your first protection in place, and then you can carry on some of the broader claims that you wanted in a continuing application. You don't have to just throw them away if you negotiate. That allows you to get something in place as fast as possible while still preserving applications. And this goes into the concept of patent pending. If you keep applications alive, a lot of times for a startup, if you keep some of those broader claims alive, it actually increases the interest of investors in your idea, in your startup, because they see that there's a pending application that claims priority way farther back, and they can take that pending application and shape it into the idea, into the product that they're actually wanting to bring to market, which might be a slightly different than the product that you thought that everybody would be interested in. And so by keeping these alive, it minimizes your cash burn because you can just respond as little as possible to some of the applications and just keep them pending, file some continuing applications, and not spend a lot of time hammering back and forth with the patent office, and preserve some patent applications for future investors to take over and really shape the way they like. Another powerful tool in a small company's patent toolbox is design patents. Design patents are fast. Not only are they faster to prepare because they primarily comprise drawings and some formal language describing the drawings. They typically are reviewed faster by the patent office. Depending on the art unit, you can get a review sometimes within 12 to 18 months is typically what you're looking at. Sometimes longer, but design patents are typically reviewed a lot faster. And furthermore, according to research by IP Watchdog, you actually get a 99% issuance rate with design patents, which is far higher than you can expect with a utility patent. What this allows a small company to do is to sprint to a patent. If you have some visual elements of your invention that are unique, you can file a design patent. It protects the look of it, which prevents a direct knockoff, allows you to quickly begin that patent portfolio and have patents to your name while you're prosecuting the longer term utility applications. And for some companies, actually design patents are precisely what they need, and they don't even have to fool with utility patents. We have a few minutes left. I'm going to briefly go over a few other types of intellectual property that you might want to be aware of. I am a patent agent. I do not practice this, but it's important for a lot of companies to know. Intellectual property is just something produced by your mind, the intellect. Like patents are a type of intellectual property, therefore they give you property-like rights, sort of like having a title to a car or a deed to a piece of land. It gives you the right to exclude others. There is no patent police, copyright police that go through and make sure that nobody's violating yours. What it does is if you find somebody violating yours, it gives you the right to stop them. Intellectual property includes patents, copyrights, trademarks, and design and trade secrets. Copyrights basically protect expressive works, art, photography, written work, including computer code, sculptures, which can include overlap design patents in that they can include the way something looks. These, a copyright actually comes into being based on our law as soon as the copyrightable product is made. However, before you file an infringement suit against somebody, it actually has to be filed with the Library of Congress. Trademarks protect the way that you brand your product or service in commerce. It actually is similar to copyrights in the sense that you actually have a trademark as soon as you start identifying yourself that way, but enforcement is typically strengthened through registration with the Patent and Trademark Office, actually the same office that you work with for patents. Trade secrets rely on you maintaining something with secrecy, and as long as you, and requires that you take efforts, like the Kentucky Fried Chicken recipe. When they move it, they've spent hundreds of thousands of dollars to move it in an armored truck to make sure it's maintained secretly. However, because it's a trade secret and not a patent, they've been able to keep that for decades, much longer than they would have had a patent. And so they've been able to preserve the value of that. So a lot of it depends on what type of intellectual property you have, whether it's useful as a trade secret or a patent or copyright. To wrap it all up, going back primarily to patents, there's two main concepts that you want to consider when you have a startup and you're looking at protecting your invention. You want to maximize your invention and you want to maximize your investments. So your invention, file before you disclose it, if at all possible. Don't accidentally give away your idea to the public without receiving something in exchange. File early, file often. Don't miss that 1-year deadline. I don't know how many people have called, I have a great idea, but they've been telling everybody about it 18 months before. Build a patent portfolio as much as possible by filing every improvement and then building from there. And then maximize your investment in protection by utilizing design patents and other forms of intellectual property, doing as much legwork as you can yourself in order to maximize what your legal professional is helping you with. Cover your core concept as soon as possible, and then keep other improvements pending so that you can maximize the interest of investors. Again, I'm with Bold Ventures Patents. We do patent application service and work with design patents, utility patents, provisionals, and international patents. If you have any questions that you can't think of today, please feel free to call or email me. My email is there. It's also on my business card and on the flyers that are on the table there. Does anybody have any questions?
Are you located here in Temple?
I'm located in Belton, yes, sir. But we travel pretty much to wherever the inventors are.
You know a patent attorney in Plano called Daniel Swayze?
I've heard his name. I'm not very familiar with him. No,
he
sir.
got a patent for the main competition.
No.
I thought if I did care for money for this project, I might go to him.
Yes, sir.
Would that be wise?
It's
the same thing somebody else.
There's sort of some pros and cons there.
Would he be in any kind of conflict of interest?
It's potential. If you're a direct competitor and it's something that might be adverse to the interests of his clients, then he may need to get a written disclosure from both you and the other client and a written agreement that you're aware of the conflict of interest and are okay with it. The flip side is that if he's already gone through that
was my thinking.
He's had that experience, then he may be a good one to go to because the competitor's already paid for him to learn how to get that. Yes, sir. Now, on the other hand, you want to carefully scrutinize the patents that anybody that he's gotten in that field, because a lot of times you can get patents that aren't very useful, and it's a balance in any field, whether or not how useful are these claims and how broadly can I get them. Sometimes you can only get very narrow claims, and that's all you can get, and it's still useful because it keeps people from direct competition. So you'll want to look at the claims particularly to see what they've done. So, and then you'll also want to ask him how he practices. A lot of patent professionals haven't really caught on to some of the patent office's initiatives that really encourage what they call compact prosecution, getting it through as fast as possible by dialogue between the patent agent or patent attorney and the examiner. And so you're going to want to ask them how they do that. A lot of them have, and it's really turning out some amazing results, really helping applicants minimize how much money they spend on useless argument when both people are misunderstanding the other.
Swayze advertises it's cut rate, like Charles Schwab.
Well, that's great.
He makes it clear, if it's a very simple utility patent, he doesn't charge too much.
Right.
Some complex thing from
Right.
other pages.
Right.
It's different.
Right. Yes, sir.
How does getting a United States patent relate to protecting internationally?
It pretty much doesn't. However, I'm not sure, would you mind elaborating, like, are you asking if a US patent protects you internationally at all?
Yes.
No. Because a patent is granted by the sovereign jurisdiction in a nation. And so the China, England, Australia don't recognize the sovereign right of the United States to grant a temporary exclusivity on something. So they're not going to recognize it. However, there is a patent cooperation treaty in place between a lot of nations, including Australia, England, EU, and how that's going to shake out with Brexit, nobody's exactly sure, but most likely it's not going to have a lot of impact. There's a lot of desire to pretty much keep it status quo. That being said, patent cooperation treaty actually allows you to file an application in a participating country, which the United States is one, have it examined by one country, and then the other countries will, I guess you could sort of say, give it, depending on the country's exact practice, either give it a cursory examination. In other words, they'll take some of the work that the other country has done and recognize it and not put you through the same gauntlet that you had to run through in every single country. It allows you to, it's expensive because international patents, the filing fees and everything are expensive. And yet it does allow you to sort of not have to go through the same thing again and again and again by allowing you to do a lot of work in one country and have it used in other countries. So the answer is United States patent. Short answer is United States patent doesn't give you any protection in other countries. But you can file a patent application in the United States through the International Patent Cooperation Treaty and get some leverage out of that in applying in other countries. The other thing that can help is that it can help protect you against competition in the United States, because if people are making it, your idea, your patented invention in, for instance, China, and then importing it as a competition against you in the United States, you can actually file an infringement action with the customs agency and get them to seize or stop the importation into the United States that's violating your patent. So that's actually a very powerful tool that some recent cases have actually made very attractive to a lot of people, because it's a lot of times faster to prosecute in the customs courts than it is in the traditional U.S. court, in district court, and appellate court. Does that answer?
It does. So are you relying upon the fact that the U.S. market is a market that people want to enter?
Yes, sir.
And therefore, there's a disadvantage to somebody from another, manufacturing in another country to not be able to sell in the United States.
Precisely. They would have to, legally, they would be required to get a license from you if they wanted to sell their product within the United States. So what you think of the patent is what you primarily think of a patent as covering your target market. Now, if 50% of your market is going to be in some European countries, or if 50% of your market is going to be in China, then it very likely will be worth your while, worth the investment of filing international applications. However, if 90% of your market is going to be in the United States, it may not be a good investment to file international applications. So a lot of it's a pick and choose, and it forces you to really hone in on what your target market is and then make the best choices from there.
What if you have filed in the United States and later on you realize you want to patent internationally? Is that doable?
It depends on the and this gets into, it's very fact intensive. If you have only filed an application, there's a certain period of time that you can file an application. You can designate it as a international application and then file it in other countries. If it's already published as a patent, and potentially if it's already published just as a patent application, chances are you cannot file it in other countries. So a lot of it depends on the exact, how it was filed, when it was filed, how, what options were chosen when it was filed. So it's not a, it's a very detailed undertaking to go through international application. So.
How do you deal with it?
Yes, sir.
You kind of alluded to utility patents need to be somewhat demonstratable.
Yes, sir.
How would you respond to, I mean, sometimes you get an idea as a futurist type thinker.
Yes, sir.
Of something that's coming down the road, but
right.
The technology's not here yet. It might be here in 5 years.
Again, I feel like the problem is in patents, a lot of times general questions like that are going to get the same answer. It depends. It's a fact-intensive, fact-specific scenario by scenario answer. That being said, the patent office, the patent statutes do not actually require that you have made the invention. All they require is that you have reduced it to practice. There's a concept, and that's the legal term. There's a concept called constructive reduction to practice. As fancy language for saying I wrote it down how to make it. So if you can write it down with enough description that somebody who understands that field, in some fields, that doesn't mean when we say, you'll hear the term posita a lot or variations thereof, a person of ordinary skill in the art meaning the area that you're in. If a posita, that person of ordinary skill, if we're talking about computer chips, we're not talking about any Joe off the street or even any engineer. We're talking about computer chip, potentially PhDs. If we're talking about semiconductor technology, we may be talking about postgraduates are the persons of ordinary skill in that art. So just because, as long as you can describe it with sufficient detail in the patent application, that you can convince the patent office and potentially courts that you've described it with enough detail that a person of ordinary skill in that area would be able to make it without undue experimentation. Not without any, they might still have to figure out some of the details, but without undue experimentation, then the patent statutes actually provide that you're able to get a patent.
So would you recommend somebody go ahead and do that, or sit and wait for a couple of years to see?
A lot of it depends. And this may be a better question in your exact scenario in a private conversation. But again, a lot of that depends on the specific scenario. Do you see that other people are moving in that same direction and are probably going to beat you to it? Then file what you know. You don't have to have it all designed out. In fact, the nice thing about a provisional application, and this is a double-edged sword, is that it's never examined. You have 1 year to file a non-provisional application that claims priority to that one, and so gets the benefit of that date. The double-edged sword of that is that it's never examined. So if you disclosed in your provisional application A and B, and in your utility application you claimed the combination of A, B, and C isn't protected by that original date. And potentially, depending on the scenario, a competitor can argue that it doesn't cover A and B either because C was required to make A and B work. So it gets complicated. But still, if you've got a question, a lot of times the default position is file a provisional application with what you know. That being said, if it's a technology that really you just have a vague idea of how it works and you're able to keep it secret, then sometimes it's better to just sort of keep it quiet and look and see how far I can push it forward. If I'm on the cusp of understanding something that will make it more realistic, then you might want to wait to that period. But
and speaking to that, the secrecy thing, there are some items, some processes that you may not want to.
And that is true. And that's something we didn't really touch on, is a lot of the types of intellectual property are complementary. We mentioned that copyrights and design patents have overlap. What we didn't mention is that sometimes for the same business, they might use trade secrets and patents. Patents to cover the things that have to be made public anyway, and patents to cover things that it's going to be hard to keep secret, and trade secrets to cover their little secrets of how they actually do things. So
Like an app. They have a trade secret.
exactly, you could have a trade secret for how things work. I'm dealing with a patent right now where we're describing how a secret process works, and yet there are elements of it that they're very definitely keeping as trade secrets because they're the ones who went to the work and figured out how to do it, and it's not really obvious, and that's perfectly fine.
For the purposes of potential health and bioscience, we work with startups, and one of the questions that comes up is you have people in academia who are developing molecules, and they want to be the first to publish,
Right.
get an NIH grant. But the minute they do that, if they have not filed intellectual property or a patent,
Right.
they're doomed. So how
Not doomed. That's where the United States 1-year grace period comes in. They're doomed in some.
1 year.
Exactly.
That 1 year level may not be enough to get proof of concept.
Right.
And be able to develop it and something that's
Right.
usable. So I wonder, and then that's one question, is, how do you handle that? And the second one is, if you file within 1 year, if they're going to take 18 months to answer you, the provisionals, which you got to file within 1 year, right?
You just have to file something, either provisional or a
And
non-provisional.
whatever it takes to get the patent later.
Right.
That's their business. But
Exactly.
you know,
Once you have the disclosure on file with the patent office, your date's secured. As long as you don't do something later on to lose it, like not respond to the patent office or come up, you might lose an improvement if you don't file the improvement, but what you have actually filed is now that date is secured as long as you do what you're required to when the patent office gets around to responding to you, that you respond within the time allotted, stuff like that. So yes, that one is once you have it on file with the patent office and follow all their deadlines, and they don't give you near as much time to respond to them as they give themselves to respond to you, but that's the nature of things. Something like that. At any rate, as long as you do that, then it doesn't matter how long they take to respond to you. In fact, there's actually a thing called a patent term adjustment, where if they take too long, it's their fault to respond to you. Then they actually extend the length of your patent by however long that was, because a utility patent is 20 years from the date of filing. And that's the other thing that you have to take into consideration when you're claiming priority to previous applications is, if you get too carried away with that, you can have a patent that's issued a day before it expires, because you claimed priority way back when. But that's sort of edge cases. But if they took a year that you just sat there waiting on them, and I forget what the time is that they've set as being reasonable. But if they take longer than that expected reasonable time and you responded in time, then they will extend your patent. It will be 20 years plus however long it took them to get around to doing it. So it's not entirely unfair there.
So it's no longer possible to game the system like Sullivan did with the automobile patent. He kept asking for extensions, and he first filed 1885 or something, and didn't actually get a patent until 1903 or something like that. He just gamed the system.
Yes, I think because of applications like that, they did. I think that's one of the reasons they changed it from 20 years from filing. A design application, on the other hand, is 14 years from the date of issue. So that's still. Back to your original question about academia. It's a balance, and a lot of times, the other concept that comes into play is that it had, like, for instance, the on sale bar that we talked about, where once you've made an offer for sale, only comes into play once the invention is ready for patenting, which means it's reduced to practice. So if you just discovered this DNA, and you're trying to make a test for it, and you disclose the DNA, that doesn't trigger the on sale bar. If you talk to somebody about commercializing at that point, because it wasn't ready for patenting yet. Does that make sense? You haven't actually made it. Your invention wasn't complete. It allows for experimentation, and so Right. Now, if you publish that DNA, I mean, now the kicker here in this example is that DNA isn't patentable anyway. But
DNA just as an example of a generic.
right.
Which is, but the point that you're bringing is that if they publish, let's say go to the NIH or they give this
Right.
grant,
Right.
and now they publish this stuff. You don't have protection. I mean, anybody can then use that molecule if they want to do it, right?
Exactly. Within after 1 year. I mean, they can do it in the 1 year, but they risk you getting a patent on it and coming back and suing them for infringement. But if you disclose it, as long as you file that disclosure, enabling disclosure within 1 year of that disclosure to the public.
If you're going to publish something, so we could really step back and I'll be quite simple. We should have a question. Let's say you have an inventor, the guy who's got a molecule, and he goes to wants to get a grant. So his application for the grant now tells all discloses all this stuff. It's not public. It's just to the NIH.
Right.
Or it's just the SRB or whoever.
Right.
But once they get the grant to do that, and once they actually do the experimentation, at the moment of publication, you're saying they have 1 year from then.
Right. From the moment it becomes public. And the concept, it helps to understand what the concept is behind that. And the concept is you can't give something to the public and then take it back. And understanding the way that our system and academics works is that that the United States preserved against international opinion the 1 year grace period. Because a lot of nations actually require that you've already filed it before you disclose it. As soon as you disclose it, you're done. But the United States hasn't done that. So if you disclose it, I mean, the best practice that we encourage is better safe than sorry. File a provisional with what you know before you disclose it. But if you don't do that, and a lot of times that's not realistic, you're up against a filing deadline for the grant, and if you don't get the grant, it doesn't matter if you have a patent application or not. So that takes priority. Well, you've still got the 1 year thing, but don't cut it close either. As long as you file within 1 year, then you can go ahead and get the patent going, and you haven't lost your deadline. And then that's why we typically recommend filing a provisional, because say you file a provisional 6 months after your disclosure, and then your experimentation shows something else up, you can file another provisional. And then when you get to not too long before the provisional is about to expire, you can file your full application with the claims and everything. And just a note on that, you'll hear that some people, there's a saying going around, friends don't let friends file provisionals. And that's primarily because a lot of people will actually have the idea that a sloppy provisional is okay. Sometimes it's better than nothing. If you've got 1 month till the deadline and that's all you can get in, that's better than not having anything. But a lot of times it shoots you in the foot because you've now passed the 1 year deadline, you filed a provisional thinking you were okay, and it really didn't cover everything that you wanted it to. And that's really where a patent agent comes in, is that the number one mistake that inventors make in trying to draft their own applications is they describe the way that their invention works. And what a patent agent does is say, okay, that's important. We need to know how the invention works. But what if you did it this way? What if you did it this way? What if you did variations? And we're going to include, 3 tables of different variations. Exactly. Exactly. So that when the patent office comes back and says, hey, we already knew about this, they say, oh, yeah, but did you know about this little detail? And so, sometimes the randomest details are the difference between you getting a patent and you not. So that's why you don't want to schlock on the description. So
I recall one patent I ran across years ago. A man invented a type of heat engine that was just completely crazy, it would work. But the claim, obviously written by the attorney, it made a lot more sense than his patent writing, claimed all such devices. Is that legal? His device, as I say, was crazy. Well, nobody could do that. But the claim claimed all such devices.
All such devices. There is a concept. I'm not having seen the application. I can't really say whether it was particularly legal. I mean, there's a lot of patents that end up getting invalidated because they find something else that was prior art. Or they argue that it was described wrong or something like that. So that can be a problem. You don't want to be too ambitious with your claims, especially. But there is a concept, a legal concept, and the legal name's escaping me at this very moment. I was just thinking of a minute ago, but where if I claim a water bottle, okay, and I was the first one to come up with a bottle to put water in, and I claimed it in the context of putting water in it, is that within the life of my patent, it still might cover a bottle with Coke in it, because it's obvious to put Coke in it, and it was just because I did it in the context of water, I didn't limit it necessarily to just having water in it, and so you can actually, so sometimes your claims can actually cover obvious variations. That's like, okay, they didn't have Coke at that time, but if they had Coke, of course they would have claimed it because it made sense. And so sometimes in drafting, patent professionals will try and include language that sort of triggers that concept. In fact, in a lot of applications, you'll read, this disclosure provides various example embodiments. But there are obviously other variations that are not specifically described that are incorporated within this disclosure. Right.
The original patent's really crazy idea. You're driving, it's a heat engine, you're driving hydrogen gas from one metal hydride to another, and expand it between to generate electricity, whatever. Well, this guy, which is a good idea, he's going to have radioactive piles, and it's going to be, the hydrogen is going to be absorbed into a heat absorbing device, or metal hydride,
Sure.
driven out by atomic energy. I mean, hot, incandescent, radioactive hydrogen is not a really good idea. Not a practical thing. Ran on the pages, and the guy must have spent a lot of money in the drawings and the whole thing. But his patent agent had a lot more sense than he did. He said he would describe all such inventions driving hydrogen gas from one hydride to another. But he didn't mention any other possibilities.
And sometimes that can actually be legitimate. We described the basic way it worked. If it's something that's known how to do, we describe this, but it's known variations on that can actually be included. That's where you can sometimes get into trouble with the patent office later, or the court later going, that's great, but you didn't really disclose it and it wasn't obvious. So it's sort of a fine line to walk. It's better sometimes you try it because it's better than not trying it, but sometimes you also don't count on it or you'll end up in bad shape.
I think we should also know the patent office does a certain amount of sloppy work.
That's true. That's true. That's definitely.
Yes.
That's definitely true. And some days more than others, you'll find your patent agent, a little grumpy from having talked to the patent office.
Do the research. Patent office will do some research, but it's up to you to find out what's due or not. So,
well, yes, and yet it's sort of and I have to explain this to a lot of patent examiners, is that we're actually not at odds. Your job is to make sure that we don't claim more than we're entitled to. But on the other hand, we don't want to claim more than we're entitled to either, because then the patent's invalid. So we're really trying to work together here. You're seeing everything else. We know our invention, and so we're trying to work together here to get something that claims exactly what this inventor is entitled to. And so,
I think the patent that guy in Fort Worth got some years ago, new type of heat engine. But I'd read about the same thing in a British scientific journal about 20 years earlier.
Yeah.
His patent was just nonsense. But evidently he didn't do the research. Not patent office didn't do it either.
And sometimes it's random too. I mean, you do the best search you can, and things come up in the funniest ways.
Popular scientific journal out of Britain, kind of like Popular Science, Popular. Well-known publication, maybe not in America, but most of the world.
Right.
Describe the exact same device.
Yeah.
This guy spent thousands of dollars getting something that's worthless.
Yes, sir.
Well, there's another aspect to this that you haven't talked about, defendable. Your patent has to be defendable.
Exactly. And
you have to be.
There was only so much we could cover in 40 minutes, but
The whole patent. But as a startup, getting a patent, get the patent, you still have to be able or willing to defend. You may have to be able and willing to defend it.
It's true. It's true because there's actually a couple of ways. I mean, the obvious thing is that somebody can challenge your patent in court. But with that American Invents Act sort of came another double-edged sword is IPRs, inter partes reviews, were changed so it's actually a lot easier to invalidate somebody's patent before the patent office instead of in the court. And so that's something, and that's really where when you're drafting an application, you want your patent agent to be aware of court cases. And that's why I spend a fair amount of time reading court cases, not because it helps me get a patent, but it helps me write strong patents because I know here's what's happening right now before the courts and here's what they're considering allowable. And so you want to make sure that your patent professional is doing that so that they're staying up with, because patent law changes. The Supreme Court at this point thinks, patents are great. And right now they're not sure if they even like patents, and so it sort of goes back and forth like that. It's sort of starting to come up. For a while their software patents were pretty much off the table. Now you might get one maybe, but if you did get one, it was probably going to be invalidated later. Things are sort of changing as people are going, you know what, a lot of our inventions are in the context of software, so we better allow people to protect them or we're going to be behind Russia and Czechoslovakia. So at any rate, along those lines, though, that's really where the written description comes in. You not only want it to be able to support your claims and any amendments while you're arguing with the patent office, you also want it to be able to support it when it's challenged before in an IPR or before the federal circuit or something like that, because they're going to say, I don't know how many times you read a decision and they go, great claims, but they're specific. They amended it during prosecution in order to get around some prior art, and their amendments weren't really supported by their specification. That's why, a lot of times, you'll have a claim and you'll have all this extra writing in the specification to cover all the cases, outlying cases you can think of and can't think of, and so, and the other thing is that you want to make sure you write claims that are as broad as possible, but are still distinctly different from what else is out there. You don't want to get right up to the edge. You want to be just, a couple inches away. That way there is a distinction and it doesn't end up getting challenged. And then there's also just, we're humans. We can only know so much, but that's really where a lot of missteps can be prevented by working with somebody who's aware of what's going on and who makes it a point to understand not just how to get a patent, but how to get a patent that's actually going to be worthwhile something to you down the road. So. And what other people will point out is that there is a value in having a patent period, even if it's not necessarily a great patent, because it might not keep a sophisticated company away from you, but it might keep an opportunistic company away from you. One who says, hey, this would be really easy to copy. Let's just make a copy. And they go, oh, they've got a patent. You know what? It's not worth the hassle. And in rapidly innovating areas, especially where most of your competition is small to medium-sized companies, that's particularly true because you might not have the resources to drag multiple cases through all the way up to the Supreme Court, but neither do they. So, and then there's always the examples where, even the big companies aren't always as sophisticated as they might be. There was a story of a guy in MBA. He came up with the fire escape ladder. His sister and her child posed for the product packaging, and he was doing it as part of his school. But then he formed a company around it afterwards. He presented it to Walter Kitty. They talked to him, and they decided they weren't interested in licensing his patent. He goes to a trade show a year or two later, and they've copied it down to the picture of his sister and her child on the product packaging. Let's say he didn't just get the value of the license that was missed, but he also got some punitive damages, enhanced damages as well. So sometimes they're not as sophisticated. Crooks aren't always as smart as you think they should be. So.
Well, on that happy note, I think that probably concludes today's webinar. And Timothy, we want to thank you so much for joining us in Temple and for the engaging conversation. Again, if you want to access Timothy's email via the handouts, I'm sure he would love to hear from you.
Absolutely.
Or you can visit him online. The web address is there as well. And just a quick reminder that we'll upload this to the THBD YouTube channel soon, so you can reference the presentation there. Thank you.
Thank you.
Thank you.
If you have a second,
Right.
could we look up something?